What next for President Uhuru Kenyatta and Raila Odinga after the High Court ruling on the Building Bridges Initiative process? Is it the end of the Building Bridges Initiative process? Or is there a chance that they are going to appeal successfully the ruling? In this video, I want us to look at the options which are available to President Uhuru Kenyatta and Raila Odinga. Because the High Court ruling today is a victory for the Deputy President William Samoei Ruto. Because strategically, William Ruto indicated that he was not going to oppose and he was not going to support the Building Bridges Initiative process. But today's victory is a victory to the Deputy President. Because you all know that majority of the cases which were filed at the courts were actually filed by the people allied to the Deputy President. But before we go into all those details, if you're watching this channel for the first time, I want you to take a second, just a second or two, and click the subscribe button so that next time we produce a video like this, YouTube will automatically notify you. And to the subscribers, I want to continue. Thank you guys for your continued support. Thank you so much once again. Now, let us begin. And I want to begin by going through the ruling. Certain issues which I picked from the court ruling. The first thing I picked was that no room for popular constitutional amendment initiative by the executive. The judges agreed that a popular initiative must be initiated by the people and not the president. In the case of the BBI, they are claiming that the president ought to have initiated that bill as a private citizen and not as the president of the Republic of Kenya. The question which I ask myself is just simple. How can you separate President Uhuru Kenyatta, the president, and Uhuru Kenyatta, the son of Jomo Kenyatta and Nina, the private citizen? So they're saying Uhuru initiated this bill or this process as part of the executive. Number two, and by the way, I don't have a problem with that. Number two, they're saying the BBI steering committee was invalid, lacked Public Service Commission nod. Let me take you to a ruling which was made by the same High Court on 4th of March 2020. That's last year. In a case by Third Way Alliance against the Building Bridges Initiative Task Force. Justice Mativo at that time ruled that number one, the BBI task force was formed legally. So in March last year, there was a court ruling that the task force was actually formed legally. And he also ruled that the BBI task force was formed to evaluate our situation and give recommendations. And it added that the president acted well within his powers in forming and gazetting the task force. That was in March last year. Today's ruling is clear that the Building Bridges Initiative Steering Committee was invalid. So I don't know, probably that gives them an opportunity or a window to challenge the ruling. Number three, the ruling is saying that the steering committee did not avail report to the public as required by law before collecting signatures. So the law is clear that before you collect signatures, because the law also just requires you to collect 1 million signatures. The BBI process collected 5 million signatures. And the law, according to the judges, you are supposed to receive the report before collecting. They're supposed to actually give Kenyans, avail the report to Kenyans before collecting signatures. And I remember President Uhuru Kenyatta and Raila Odinga, was it at the Bomas of Kenya? officially launching this report. By that time, signature collection had not begun. So I don't really understand what they meant here. And probably someone should define what a report is. But let us wait and see. So that also, in my considered opinion, gives them a window to appeal. They are saying at number 4 that there was no public participation. What is public participation? In public participation, it means Kenyans are supposed to be involved. But how are Kenyans supposed to be involved? There was a meeting in Kisumu, Ciala Resort. There was a meeting, I think was it at Sagana. There was meetings across the country before the county assemblies voted. But I'm not sure whether public participation should happen before the vote. I don't know. Number 5, which also caught my attention, is that amendments to the constitution must be separated and voted upon individually, not lumped together as an omnibus bill. Basically, they are saying that if you want the prime minister, you separate. If you want the deputy president, you separate. If you want, whatever you want in the constitution, you must separate all those issues so that you have a multi-choice referendum. Is there a chance that someone influenced these people to make this ruling? Because if that's the case, then it means even the Punguza Mzigo initiative, which most Kenyans hailed on this platform, was going to be unconstitutional because it also just lumped the issues. The 2010 constitution, which Kenyans voted for, never had multi-choice. Of course, in a referendum, there's the choice of a multi-choice referendum, and also there's the choice of if you want multi-choice. But why are they forcing that it has to be multi-choice? If you don't want the referendum, the bill, say no. If you want it, say yes, the way it is. If you have an issue with only one and it can make you throw the whole document, do that. But now they're saying you must separate issues. How will you separate issues? If it's an IBC, someone will come with another issue on IBC. But I don't know. I don't understand. On that, I don't want to argue with them. But probably someone will go and seek for interpretation in the courts. So they're saying at number 6, which I totally agree with them, that directing IBC on how to delimit the 70 constituency is an affront on its independence and violates constitutional principles and criteria, hence unlawful. You see, the Building Bridges Initiative process ought to have identified that they needed 70 more constituencies. And then they leave the task of dividing or allocating those constituencies to IBC. What they did, and which I disagree with completely, is that they decided that this constituency is going to get this constituency is going to get this. We know the role of IBC. So they ought just to have given IBC that we need 70 additional constituencies, and this is going to be the criteria. Then IBC was going to come up with a number. But remember, there were politics behind the BBI. President Uhuru Kenyatta wanted to appeal to the people of the larger Mount Kenya region, that he values them. He wanted to allocate them more constituencies at the expense of the rest of the country. So on that, they ought to have listened to James Orengo and Otienda Molo. What James Orengo and Otienda Molo was telling them, if they had changed it in parliament, would have solved this particular issue. The 8th thing, which also caught my attention, was that IBC didn't demonstrate to the court that it had conducted continuous voter registration. And if so, when voter registration was last conducted, it only stated without evidence that it conducts continuous voter registration at constituency headquarters. On this, I also disagree with these guys. IBC is supposed to conduct continuous voters registration to allow Kenyans to participate. But I think IBC cannot force people Today, if you want to go and register as a voter, you can register as a voter. That's the honest truth. So there's a continuous registration of voters. I don't know the kind of evidence probably they needed to prove to them that IBC conducted voter registration continuously. The truth of the matter is that in this country, we are going to have another election in Georgia and Bonchari. This ruling means that someone is going to lose those elections and going to cite this ruling that IBC did not conduct continuous voter registration in their constituencies. And again, even in the last constitution, we didn't have continuous voter registration. I mean, it's there, but most people don't even know that we normally have continuous voter registration. So that one can be challenged, if you ask me. Now, let me get you something which is also very interesting, which is my last point before I go into what next. Now, number 9, that IBC lacks this statutory quorum of 5 members and is therefore unlawfully constituted. It did not have the capacity to verify the supporting signatures of the BBI bill. The decisions made on the bill were invalid, null, and void for want of a quorum. So basically, they are saying that IBC should have 5 commissioners to form quorum. That's when they are lawfully constituted. And because they lacked quorum, they did not have the capacity to verify signatures. Now, that one, someone can go to court. IBC recruited people to do the verification. Commissioners don't do the verification. Probably if there's the issue of quorum, then that's a different case. But saying that they didn't have capacity, while the IBC spent taxpayers' money and people were hired to conduct, people actually hired to conduct the verification. So I read a lot of questionable ruling in this document, in this ruling, but some of them are sound. Let us go into politics now. What next for President Uhuru Kenyatta? That's the question. In my considered opinion, President Uhuru Kenyatta and Raila Odinga must go back to the drawing board. And again, as I keep on saying on this platform, that in politics, nothing happens out of mere coincidence. Is there a chance, any chance, that the deep state had figured out that this bill was going to fail at the referendum? And therefore, the best thing for them to do was to stop this process, or was to engineer the collapse of this process. And that takes us to the first option for Raila Odinga and President Uhuru Kenyatta. Stop the Building Bridges Initiative process. So they have that option. So that after this ruling, they just say, time will not allow us to conduct another referendum before the election. So they just stop it. Because the truth of the matter, perceptually, this process is not very popular. But based on the voting at the Senate, at the National Assembly, and at the county assemblies, there's generally agreement that those who are saying no are carrying the day only on social media. But qua ground, the yes have it. So because the yes actually have it on the ground, they should not stop it. But that's the first option they have. Stop the Building Bridges Initiative process because it's unpopular. He can also use this, especially President Uhuru Kenyatta, to appeal to the emotions of the people of the larger Mount Kenya region. The moment the Building Bridges Initiative process is going to collapse, Uhuru Kenyatta can go to the people of the larger Mount Kenya region and tell them, I wanted to give Kiambu additional constituencies. But Team Tanga felt otherwise and opposed each and every step I was making. And I'm now exiting political scene. How will you guys ensure that if you elect William Ruto, he's going to initiate or support some of these things? He's not going to do that. So support Raila Odinga, so he can use it to appeal to the emotions of the people of the larger Mount Kenya region. Again, why they should stop it is probably because of political formation. I said recently that this BBI, it favors William Ruto both ways. Either if Kenyans vote yes for it or no. If Kenyans vote for it, then it will give William Ruto the opportunity to also appoint a running mate, appoint a prime minister, and appoint 2 deputy prime ministers. As things stand today, William Ruto is in a fix. Who is going to be his running mate? And will Kikuyu accept someone outside central Kenya to be William Ruto's running mate? Well, they're going to be expected to deliver votes. So the president was likely, or is likely, to use that trick to win against the deputy president. So that's the first option. The second option, which I'm sure someone is going to do, is to appeal this ruling. I listened to Professor Sihanya poking holes into this ruling. Of course, there are certain issues which a higher court cannot agree with, especially in this ruling. So they can appeal. But if they have to appeal, they must make sure that after they appeal, the court must give them a victory. Let me tell you what's going to happen. This case is likely to go up to the Supreme Court. But I'm sure within the next 2 days, next week, someone is going to go to the court to challenge the ruling. He's going to go to Court of Appeal. The Court of Appeal is going to overturn this ruling, which in my considered opinion is thorough. The ruling by the 5th bench is thorough. But it has some issues which someone can really dismiss. When you talk of public participation, a lawyer will just prove that public participation happened or took place. And lastly, which I think is important, Uhuru Kenyatta's relationship, or the executive relationship with the judiciary, is wanting. These guys are fighting. The BBI is proposing to establish ombudsman. Ombudsman are going to deal with cases like this one, so that if a judge makes a ruling, then someone can go to the ombudsman and the judge will be investigated. Which judge is going to allow that to happen? So how can they deal with that? Just look for ways of stopping the Building Bridges initiative process. Because in their ruling, the ombudsman, they've not even talked much about it. I don't know what to think. But that's my take. Again, if you're watching this video for the first time, this is Lee Makwiny, inspired YouTuber, supported by loving subscribers. Please just take a second and click subscribe button. And it's my hope that this video is going to find you in good health. Basically, I hope that you've watched this video in sound and good health. Thank you guys, and please may you have a good day. Tomorrow I will be heading to Homa Bay. Thank you, and if you are in Homa Bay, tukutane huko.